Hello again, this is attorney Mark Bruner, and thank you for joining me again on Talking Texas Law. And the question for today is?
So I'm out on bail and I got a list of requirements, but I haven't been convicted of anything yet, so I'm not sure if they can do that to me or not.
You know, this happens quite a lot. You know, someone is out on bail, they got arrested for something, they've made bail, they go to court, and now all of a sudden they're told to do a bunch of stuff or not do a bunch of stuff. How is that legal? Well, here in Texas, Chapter 17 of the Texas Code of Criminal Procedure allows and authorizes judges to issue what are called bond conditions. And so these are a list of things to do or not do. And if a defendant doesn't do those things, well, a judge could revoke or take away or raise the amount of their bail, both of which could result in the person going back to jail, having to spend more money to make bail really all over again. And that results in, again, more money, more hassle. So those bond conditions are important. You know, bond conditions in Texas fall into two broad categories, general and then offense specific. Let's talk about both, starting with general bond conditions. You know, general bond conditions are a broadly worded list of warnings that a court may give a defendant, such as don't break the law, show up to court on time, don't do drugs, stay in contact with your lawyer, things like that. Again, having nothing to do with a particular case, but just broadly worded warnings. And again, failure to do those things, to abide by those bond conditions, could result in some bad things. You know, it's important to note that these general bond conditions don't even have to be spoken aloud by the judge or issued in writing formally by the bench or put down somewhere to apply. So, for example, if someone's out on bail on offense X and 2 weeks later they commit offense Y, it could be a different county, a different judge entirely, but that first judge, based on that second case, could raise or revoke that first bail. So again, it pays to abide by these general bond conditions. And so again, as the old saying says, ignorance of the law is no defense. So even if a criminal defendant has not been specifically told, don't do drugs, don't break the law, come to court, failure to do those things can result in some pretty bad consequences. Let's talk now about offense-specific bond conditions. And this is where judges can get really creative, depending on the nature of the offense charged to that particular defendant. Let's say it's an alcohol-related driving offense, like DWI. Well, a judge authorized by Chapter 17 of the Texas Code of Criminal Procedure could do things such as require the person to not drive a vehicle unless they have, let's say, an interlock device that they blow into, to perhaps wear an ankle monitor that determines whether or not they've been drinking, to report to a pretrial officer to monitor their sobriety. There could be a whole host of things like that. For example, in a family violence case, someone could be told to move out of their house, to not possess firearms, to not have contact with their spouse or their children. There are a lot of conditions that a judge can put on a bond for certain types of offenses. And again, it can get pretty creative. A computer crime may result in someone being told you can't access the internet. An allegation of a crime against a child may result in someone being told that they can't even associate with someone who's under 18. The list goes on and on. You know, again, it's that feeling that I'm innocent until proven guilty, but the experience here in Texas sometimes with some of these bond conditions can be particularly onerous. The law says that a judge is empowered to put any reasonable bond condition on a defendant, but again, reasonableness sometimes is in the eye of the beholder. As always, here's the disclaimer. This video is being offered for informational and educational purposes only. It is not a legal consultation and should not be construed as giving legal advice. And unless you're already a contracted client of mine, I'm not your lawyer. Again, this is attorney Mark Bruner, and thank you so much for joining me on Talking Texas Law. Thanks, y'all.